sorry, we're on. Okay, thank you. That was it. Thank you very much.
So can I just give an overview of 3 key points which we respectfully invite this court to bear in mind. The first point is this idea of FRAND as involving process as well as substantive obligations, process obligations being directed to achieve the ultimate outcome of FRAND license. Second, some remarks on the nature of the license specifically sought in this case, and which both sides agree should be put in place following the October trial, and third, what the ETSI scheme requires an SEP holder to offer, and when, in the case of a business that is being conducted now and is a continuing business over a lengthy period. So first, as regards FRAND as a process, and this is one situation where I would just invite my lords to turn up the most recent authority on this, not because at least one of my lords will need to know it since he wrote it, but because other members of the court may wish to be as up to speed, let me put it like that, on these issues. And perhaps I can take some of this quite briskly, because obviously I know that my lords have been engaged in this broad area last week, and you will have seen quite a bit of the materials
Yes.
that are relevant. So it is tab 16 of the authorities bundle, the interdigital and de novo case in the Court of Appeal. And the passages to which I respectfully commend attention are the summary of the basic legal principles applicable to the determination of FRAND terms from paragraphs 21 on to paragraph 22, which summarises the ETSI policy. I don't think there's any dispute about that. But in particular, the section where Lord Justice Arnold analyses the corollaries of some of those and the Supreme Court background. And the reason for referring my lords to this specifically is that this was not material that was before the judge, obviously, because this is a judgment that came out somewhat later, and I don't think there were specific further submissions made on it. And although some of the points do pick up the jurisprudence from the Unwired Planet case, this case has rather reinforced some of the points that are important to bear in mind. And we obviously make no criticisms of the judge not having those in mind, but they are points that this court at least should have in mind. The first point is that, as has been said both by the Supreme Court and most recently in that case, FRAND and compliance with the ETSI scheme has procedural as well as substantive elements. You see that essentially picked up in paragraph 23 and developed a little bit more in paragraph 39 of that judgment. And again, I don't want to take up time now by reading them out or inviting my lords to read them. Those are just points you can read separately, but they are very important points. And they take place against the background of a point made in paragraph 23, which is that the object of the ETSI scheme is to avoid, as it has been said, 2 evils. The evil of hold up and the evil of hold out. And the reason I use the term evil, which is because that is the way in which these two points were discussed in paragraph 6 of this decision of the Court of Appeal, and they are, in some senses, corresponding. They are potential evils. Hold out is avoided by expecting a potential licensee to engage properly with a licensing process, to attempt to agree, and to submit the determination of what are fair, reasonable, and non-discriminatory terms to an appropriate tribunal for adjudication in such a way as will ensure proper and complete compensation on such terms for the use of the rights in question. That evil, continue that term, was addressed by the Unwired Planet jurisprudence. And essentially what that involves is the English court saying, in a way that is not uncommon in intellectual property rights licensing, where everyone expects that licenses should be granted, you must submit your disputes if you can't agree to, in this case, the English court. The English court will resolve these on a worldwide basis, including in relation to German patents and US patents and so forth. And if you don't agree, then you'll be injuncted. So the injunction is an enforcement mechanism to ensure that a holdout doesn't occur. Hold up, which is the other side of the coin, requires a mechanism to ensure that a patentee does not use the injunction power that the right of the patent gives a patentee for purposes other than securing, and only securing, FRAND terms, not super FRAND terms, not terms any other than FRAND terms, but FRAND terms. And once one appreciates that the structure of the system involves this balance of having a dispute resolution system which leads to FRAND terms and the procedure for a system in question supporting that, then one can see that on both sides of the balance one's got a satisfactory and working system. Now, the English courts have procedures, including procedures for dealing with things like past royalties and delays in payment and so forth that my Lord Justice Arnold wrote about in the Interdigital case, which effectively ensure that there isn't holdout, or at least if there is, it's not successful. One of the ways in which that's done, getting into the weeds of it, but it'll become clear why I say this, is ensuring that when one's doing a comparables analysis, for example, proper comparables are taken for evaluating what the value should be, and that they are not tainted by holdout or hold up, and that evaluation is done in such a way as to give a fair compensation and not a distorted compensation. Now, as my lords will know, there has been a degree of what one might describe as distrust of courts and tribunals in various places as to whether this is an appropriate exercise to be done on a global basis, whether it should be done in particular by the English court and so on. But one thing that has happened since the Unwired Planet decision is that there's been a developing and what one might call maturing jurisprudence in this area as to the substantive approaches to valuation. And that is important in this case, because what one sees is that many people in the world come to the English court recognizing, having seen the way in which the English court looks at matters, that this is a fair, efficient, actually reasonably timely forum, given the difficulty of some of these disputes, some of which run to many hundreds of millions of dollars, for resolving matters of genuine public interest. The English court has good procedures for doing that. It enables disclosure to be given, for example, of comparable agreements, so that one doesn't get a distorted picture. It enables evaluation to take place of whether either side is putting forward unreasonably distorted spin on the strength of their portfolios and so forth in cases in which that arises. The point of this submission is not to talk up the English court, but to say this: there is a very good reason why someone like Panasonic should choose the English court to determine FRAND terms, because it is a good court to do so. And there is a good reason why Xiaomi should choose the English court to determine Fran terms, because again, it is a good court to do so. And so it's unsurprising that when Panasonic came along and said we'd like the English court to make that determination, Xiaomi said, okay, we're happy for that. And there has been an agreement that it is the English court that should be undertaking this valuation. And it is important, of course, for my lords to recognise that the English court is being asked, albeit somewhat indirectly, to undertake a valuation not just of the United Kingdom patents, but the value essentially of the whole of the portfolio. So both Panasonic and Xiaomi have submitted to the English court the question of what compensation should be paid for the German patents, among others, and the UPC patents, because that's the whole purpose of the Fran evaluation that will be undertaken. The second point on this authority is that the Supreme Court emphasised, and I don't think I need to go to the specific passage, that it's expected that commercial practice in the relevant market is likely to be highly relevant to an assessment of what terms are fair and reasonable for this purpose. And in our submission, that is a sensible approach. It's in paragraph 62 of the Supreme Court's decision, and it was picked up in IDC and Lenovo. Courts are entitled to draw on what might be called good commercial practice in the real world. The courts there, the Supreme Court can't really be suggested that they were suggesting that the courts should draw on reprehensible practices or practices which were less likely to lead to a Fran outcome, even if those practices occasionally occur. And one thing that my lords know from these kinds of cases is that the ordinary approach, or at least an ordinary approach, is for there to be, for example, standstill agreements while negotiations occur. I might say, well, the court analogy of that is standstill agreements while court determination occurs for obvious reasons, because that's, no one thinks that the alternative is a reasonable one. And it is perhaps why Panasonic's initial reaction when faced with this situation was, yeah, of course there should be a standstill. We shouldn't be going off to other courts while the UK court, which we've chosen, is looking at this issue. And the third point, and this is the perhaps key point for this aspect of the case, is that the Supreme Court said at paragraph 64 of its judgment, picked up at paragraph 28 of IDC and Lenovo, that the FRAND obligation in the IPR policy extends to the fairness of the process by which the parties negotiate a license. And one might say that when the court is stepping in to, in some senses, do the negotiation for the parties, the fairness of the process is one that also is something the court needs to consider. And I've drawn attention to the passage in that decision, paragraph 39, where Lord Justice Arnold picked up the significance of that and said that the SEP holder should not behave in a manner which promotes hold-up, and the implementer should not behave in a manner which promotes hold-out. On the contrary, both parties should attempt in good faith to negotiate terms which are FRAND. And the concept here of not acting in a way that promotes hold-up is important. In our submission, it is not necessary for there to be a finding of conflict with the ETSI scheme for an SEP holder to do something which inevitably will result in hold-up. What is being sought by way of the procedural approaches is to take a course that avoids the promotion of hold-up. And where both parties have agreed as to what is FRAND in principle, namely the determination by this court of what is FRAND, an attempt to try to get other terms on the basis of the injunctive power is at least likely to promote hold-up. Indeed, our submission is that it is one of the more regrettable forms of hold-up, since it involves trying to use an injunction power to pressurize a counterparty to accept terms which it is common ground that the court before which the injunction is sought cannot and will not determine whether they are FRAND. But where another court to which the parties have agreed to make the determination will do so. The effect of the mutual undertakings and the approach of the English court to determining FRAND terms means that there is no possibility of holdout in this case being effective. FRAND terms will be determined. The dispute resolution process is directed to that, and both sides have agreed to enter into a license on those terms, which address future and past acts of infringement. And it is significant for this reason. No one, not we detect, even Panasonic, suggests that it would be appropriate or contemplated by the ETSI scheme for a license between a patentee and an implementer to be on terms which are not obviously unFRAND. The concept of not obviously unFRAND is unknown to the ETSI scheme. And the reason I use that term is because that is the approach of evaluation that the German courts adopt in deciding whether or not an implementer has made an offer that in principle requires whether the SEP owner has made an offer that in principle requires the implementer to engage in. And I'll come on to the German court in approach in detail. So our submission is this. Once it's clear that FRAND terms can't be agreed after reasonable, and in this case quite lengthy attempts been made to do so, and the issue of what terms are FRAND for a portfolio has to be referred to an agreed and authoritative third party for determination, which both parties or the third party and the third party consider to be appropriate, it is in our respectful submission obvious that neither side should frustrate that exercise, disrupt the other side's business in the meantime, or make it unnecessarily complex or costly for that agreed dispute resolution process to resolve those terms. That is a corollary of the fact that the FRAND scheme, that the FRAND under the ETSI scheme has process as well as substantive elements directed to avoiding both holdout and, in this case, hold up. Now, there are various ways of achieving this. We don't say that there is a single procedural course that is the only one that should or can be taken. One way, which was actually Panasonic's originally favoured way, is simply to have the other proceedings, if there are other proceedings, stayed pending the result of a FRAND dispute. And in principle, although we look at this in terms of court against court, this is no different really from a situation in which one party seeks to pressurize another party to entering into an agreement by use of collateral means. So, for example, if Panasonic were to stand outside Cherry's factory and say you can't sell products, in order to get a license that was not a FRAND license, everyone would say, well, obviously you can't do that. That's not an appropriate thing to be doing. You should all stay your hands with respect to any activities, not just judicial activities, but activities in general which are likely to undermine that process. And Panasonic and Xiaomi were, in effect, agreed on this before Mr. Justice Mead until day 2. We submit that that is quite an important fact, because it might be said that the instant reaction, that's to say yeah, of course, what's sensible, is Panasonic's first reaction. Another way, and we say actually in some ways a slightly better way, having regard to all of the terrain, is the way that we are commending to my lords on this occasion, which is for the parties to enter into interim arrangements pending final determination, which ensure that the SEP owner is paid a fair, reasonable, and non-discriminatory amount for the relevant period, pending the determination, often, as the courts implicitly recognised in the IDC and referred to in paragraph 36 of the decision, again, we don't need to turn it up, that may well be, as Mr. Justice Mellor said, on the low side. And it's right for that to be on the low side, particularly if the determination is happening quite quickly, because there are circumstances in which one can see, for example, that inadequate information is provided to justify what might be regarded as a higher level of interim payment, or there are good reasons for thinking that the claim advanced is much too high. I'll come on to that when I come on to the terms. And the alternative to that approach is significant disruption. My lords will recall from the oral argument on the Ericsson and Lenovo case last week that one member of the court observed that an interim license was an answer to the problems arising in a case of this kind, and we respectfully agree it is an answer, and we respectfully submit it is the most natural answer. And as we read the transcript, this court pressed counsel for one of the SEP owners as to what justification there was for parties who had committed to a court determination seeking injunctive relief in advance of that. And it will be a matter for your lordships to consider whether you really found an adequate answer to that question, which I think was asked at least twice and possibly 3 times. And the reason is there isn't really an adequate answer to that question. Your lordships will have read parts of the judgment which record Mr. Justice Mead's critical observations. Mr. Justice Mead, who one might say is not a judge given to overstatement, said that he had no sympathy at all for Panasonic's position and found it inexplicable. Mr. Justice Zaccaroli described Panasonic's approach, having read about it in the judgment that he delivered, as egregious. And so it is. And if one just steps back for a moment and asks, given the procedural requirements of the ETSI scheme, should an undertaking engage in pressurizing conduct that can be described in those terms, pending a dispute that it knows will get FRAND terms in just a few months? I mean, by Christmas, Mr. Justice Mead has said, under huge pressure, putting the Chancery Division under huge pressure, I'm going to deliver terms. The answer is self-evidently no.
But the answer to that seems to me, look, as a commercial standpoint, would be a ground for an anti-suit injunction.
Oh yes, and my lords, I do not say in this case that there are no grounds for that. But
I have to say, from my perspective, I think what I wonder is whether this court should contemplate going into the exercise of making a final declaration, as I understand it, final declaration that a party in the position of Panasonic, if complying with its ETSI obligations, should grant a license on terms which are at the best uncertain, when there is a much more simple and straightforward recognised English law solution of granting an anti-suit injunction. And if this finish, because it seems to me this to my mind is perhaps the crucial question. If what you say is right, the proceedings in foreign jurisdictions for an injunction are vexatious. I think you say that very clearly. You have an English proceedings coming to trial in October, which will determine this dispute, and will do so retrospectively. It is vexatious and oppressive to seek injunctive relief abroad. That seems to me to be clear-cut, on the face of it, case for an anti-suit injunction. If that's the case, why should the English court get into what it seems to me to be novel and difficult territory of making declarations which have no binding effect in terms of making somebody enter a license, when it can just grant an anti-suit?
Everything my lord has said, we agree with, to this extent. And it's not just we who agree with it. Actually, until day 2 of the hearing before Mr. Justice Mead, effectively Panasonic agreed with it as well. Because
they were
that was their stance. Their stance was there shouldn't be these other seats.
Yes.
And so this is not a situation where one comes along and says, oh, well, one's granting an anti-suit injunction against what someone has said was appropriate. One would be granting an anti-suit injunction against something that the undertaking has said was appropriate until they changed their minds.
Why aren't you taking that course?
Well, my lords, the reason is this. In the context of intellectual property licensing, one of the things that has been common in this area is for there to be some kind of provisional arrangements in certain contexts. If one thinks about, for example, the Copyright Tribunal, upon which some of this jurisprudence or some of the thinking may be based, it is not uncommon for parties to say, well, we're going to make licenses that are provisional licenses pending determination. And the reason for that is because a patentee then gets paid, or in that case, a copyright owner gets paid. There's provision for reconciliation. It might be said to be, in some ways, a less aggressive, when I use that term in a very general term, approach. It provides benefits all round, and one might say, my lord, that it provides greater benefits all round than simply anti-suiting someone. And bearing in mind that the idea of the ETSI scheme is that people should be paid, and one wants this to happen sooner, it is a more satisfactory solution. It is, as my lord says, a somewhat more complex solution, because what it then requires the court to do is to consider what the terms of the license should be, make a determination of the sum that should be paid in the interim, but in this case, and I'll come on to that, it shouldn't really be a very difficult exercise. I mean, it's said to be very complex and difficult here. It actually shouldn't be. And one sees the way in which this was done in a copyright tribunal case, where there was all sorts of evidence on whether or not delay in payment would result in difficulties for the rights owner, the EOS case. And the tribunal said, well, look, there's an interim agreement. It should just basically the status quo should be preserved. And it might be said, well, actually, if the parties can't really agree financial terms, the status quo should be forget all this. Just there should be a license which should be on nil terms or some modest terms, because we're not going to get into the whole issue if there's going to be a determination at the end of the day. And I accept all of that, but the purpose of this and the purpose of this appeal is that if one is thinking about this whole jurisdiction, in some senses what the courts have done, and it is to the credit, if I may respectfully say so, of the English court, they have sought to fashion, to some degree, novel remedies to meet the specific needs of this licensing situation. One might say that Mr. Justice Burse, who originally did the Unwired Planet a set of decisions, including the concept of the Frand injunction, that was something that was, in some senses, unknown to English law before then. But what it has done, and one sees in the way that it was confirmed by the higher courts and ultimately the Supreme Court, is that the court said, well, okay, this is somewhat novel, but it is a practical, effective solution which really meets the needs of the contractual framework.
I entirely understand that in relation to the order the court will make after a trial. And all that is happening here. You're going to have the trial, and then there will be the determination of Frand, which the parties have both undertaken to accept. And that's going to happen in October, decision end of year, beginning of next year. We're only talking about what approach the English court should adopt on an interim basis. That's all we're looking at here. And whilst I can see novel approaches after a trial is all well and good, but I think this is, just to drill down into what you're asking the court to do here is, as I understand it, to grant a final a final declaration, which in itself seems to me to be quite a difficult concept on an on an interim basis, to grant a final during the interlocutory stages, of which doesn't impose any terms but declares this is what a party will do, which then puts Panasonic in the position of either agreeing or not agreeing to that. And that doesn't seem to be just novel, it seems to me to be arguably stretching the court's jurisdiction to a remarkable extent, when there is a very straightforward, well-recognised remedy, which is to say, right, we're going to be giving judgment in this case in December, January. It's quite wrong that there should be proceedings elsewhere. We will injunct them. And at that point, Panasonic has a choice. It can either say, okay, we're injuncted, there's standstill until judgment, which is what you were happy with, as I understand it, or they can agree an interim license with you.
Yes.
And at the moment, my sole difficulty with everything you said is, why should this flexible and novel approach that the English court has adopted, and which you commend, why should that require the English court to go so far as to start granting final declarations on an interim basis of that a party should take a license on terms which may ultimately not be found to be friend?
Yes. Well, let me just deal with that last point first. The whole point of the final declaration as to the interim license is that the interim license sought requires payment of a certain amount, but that is fully adjustable.
Yes.
The whole idea is to have an adjustable license, and indeed the basis on which the Copyright Tribunal authorities proceed is on that basis.
I understand that.
So that objection in all respectful submission falls away. As regards final relief, all that is being said, and we use the term interim license, and I'll come on to why that may, in some senses, divert attention, is for the court to be saying, this is the license, these are FRAN terms for the license that should operate during this period of time.
So there can be more than one friend.
Well, I'll come on to more than one FRAN.
I mean, more. So, I know there can be more than one FRAN, but can there be an interim FRAN?
Oh, I see what you mean. Yes. Well, let me. It's actually a point that I was going to come on to specifically under the second point, but I'll deal with it. Perhaps I can come on to it under this head, because you'll perhaps understand when I step back a little bit why we say that the term interim is sometimes diverting from what's going on here. As regards anti-suit injunctions, and I've just been handed a note on this, and I'll need to look at this, it is possible, as I understand it, that if this court grants an anti-suit injunction, that may be a ground for Panasonic saying that we are an unwilling licensee in Germany. And if that is so, then then the relief which may be the most natural relief, because of the way that the German court regards the procedural matters, what the English court may think of as an obvious solution to the problem may not just not be an obvious solution to the problem, it may compound the problem. Because as my lords may know, if you follow this interesting area, the German courts themselves have on occasion been the subject of anti-suit injunctions from foreign courts. And they have then responded to that by granting anti-suit injunctions with respect to the court that has granted those injunctions. And I think we were up to a maximum of 4 anti-suit injunction
But that's not
with
going to be a
different
problem.
courts.
That's not going to be a problem here because Panasonic has undertaken to this court to accept the FRAND license.
Oh, indeed. And it may be that Panasonic will say, all right, well, if there's an anti-suit injunction, really, then the game is up on this aspect, and we'll just press on with
Well, if
the
they,
FRAND
applied, if
license.
they applied in Germany for an anti-suit injunction to restrain these proceedings, they would be in breach of that undertaking, it seems to me.
Indeed, and my lord is, of course, absolutely right on that structure, and as I've said, it's not only
forgive me. I'm not sure I'm not sure this court, which has parties before it who both undertaken to accept its decision, should be in terrorum of some other jurisdiction granting an anti-suit from granting the proper relief to ensure that it can properly determine and enforce its proceedings. I mean, it would be. I'm not sure that from a commercial perspective, that sort of argument would cut no ice.
I completely understand.
Experience.
Yes, I completely understand that. On the other hand, one might say that what one doesn't want to do as a court, as this court, is to take action that would just
bog things down,
create unnecessary complexity.
But why would it? Why would it, given that both parties have undertaken to accept the jurisdiction of this court?
Right. Well, I mean, in some senses, if this is perhaps a question more to Panasonic for this reason. If it is accepted that an anti-suit injunction were it to be granted, obviously they would comply with it, but they would not then seek to do anything in the German court contrary to that, or suggest that there was anything wrong in us having obtained an anti-suit injunction in such a way that gave rise to an increased risk of an injunction elsewhere, then all of the problems would go away. But what we would be left with is a situation where they got paid later, essentially, or at least they got paid something later. It would be a less satisfactory solution overall. But I'm not saying, I mean, the heart of my submission was that is an alternative. We put before my lord what we submit is a better alternative, and I'll seek to develop the arguments as to why that is. But it's certainly an alternative. So if I can just finish this head under license. Once one appreciates that the ETSI scheme is directed at preventing hold-up and requiring the parties to engage in a process which avoids both hold-up and hold-out, we say it is not reasonable to suggest that the English court cannot and should not act in a way that is, in some senses, more advantageous to the SEP owner than an anti-suit injunction would be, and which the SEP owner thought was appropriate in earlier this year, so as to prevent that risk from occurring. Now, the judge thought that one needed to find some sort of express provision in the ETSI scheme pointing to this kind of approach being appropriate. But there's not even an express provision in the ETSI scheme conferring the jurisdiction on any court to determine the terms of any license. The ETSI scheme does not condescend to that level of detail. It is a corollary of the ETSI scheme that if one is going to have an external dispute resolution system, it must be directed to a FRAND license. So that's the first general head, and having articulated those points, I can come back and be briefer on some of the specific grounds of appeal. So the argument has made progress. The second general head is under the SEP license in this case. And on this, I'll try and address my lord's point directly by stepping back a little bit. The ETSI scheme, of course, doesn't prescribe what the nature is of a FRAND license. The key defining characteristics of any IP license are well known: what the rights licensed are, what the field of use should be as regards products, the territory, duration, whether prospective, and where appropriate, retrospective. Licenses of this kind can be of any duration. Normally, it makes sense for licenses to be global because the parties that have come before the courts generally operate their business globally, but there's nothing in principle wrong with having licenses that are more limited territorially or more limited in time. For example, if a party is leaving a business, might say, well, we only need a license until the end of next year, or we only doing business in Korea, and so we only need a license for Korea, and the terms are adjusted to take that into account. And the reason that I emphasize that point is because when one appreciates that there's nothing unusual in principle in a license being made which may have more limited scope and provisional payment mechanisms than an agreement of longer duration, it becomes easier to appreciate that what has been described as an interim FRAND license is not an unusual creature at all. It is simply an ordinary FRAND license for a given period. It is of limited duration, but that is because it is not necessary for it to be of greater duration, because there will be a license put in place that both deals with the period up to the start of the license and from the conclusion of that license under the relevant procedure. And the only reason in our submission why this has not been done before, and why, in a sense, we are in this novel territory, is because, well, we think this may be the reason, should put it like this, is because parties haven't previously said, okay, we're going to invoke a dispute resolution mechanism to determine what a FRAND license is, and then gone off to another court to go and undermine it. So there hasn't been a need to that extent to address this particular point. So to that extent, the context is novel. Of course, in an ideal world, we wouldn't be looking at this at all, because one might say in an ideal theoretical world, the English court would be able to resolve the terms of a license once it had been put before it immediately. Indeed, it would have done it already, including for this prospective period. The only reason we're in this world is because there are natural delays which the court has tried its very best to reduce to the minimum by expediting these proceedings, and therefore leaving a potential gap. And so Panasonic is obviously trying to take advantage of that gap, but it's a gap that's not that's inherent in a process of third-party resolution. The second point under the nature of these licenses is that if a patentee has demonstrated an intention actively to disrupt a manufacturer's business, the ETSI scheme would make no sense unless the SEP owner was obliged to offer a license at once, or as the cases say, on demand. And we referred, your lordships, to the authorities on this. Optus and Apple at paragraph 39, I don't think we need to turn that up, quoting Mr. Justice Mead below, where the court emphasised that there should be no restriction in terms of what the beneficiary wants to do commercially. And in our submission, that a license should be available when the beneficiary wants to do the acts in question, not only at some future date. So the authority of this court is that what has been described as an interim license is actually a license that is more properly described as a license now to do acts until a date in the future when further terms of a license for a further period in the future are to be determined. And again, once one sees the determination in that context, it becomes quite easy to see that this is, in a sense, a determination of successive FRAND licenses. And there is nothing surprising about that either, because if one thinks about copyright licensing, patent licensing, ordinarily licenses are for a fixed period and require redetermination, or the terms may be renegotiated. So you've got a license for a period of a few years, and then there may be agreements in relation to this, agreements in relation to how there should be determination of future terms. Essentially what is happening on a smaller scale is that the parties having been unable to agree this period for the license, they invite the court to do so. The court ought to do so in our respectful submission, and then the license for the future is going to be determined in the future. And so all that's being said is essentially is that an ordinary brand license should be given, and the terms that are sought, that are fair and reasonable, take account of the fact that there is an agreed dispute resolution process for the license for the future and for the past. And it is important to remember what the nature of the license is that the parties have agreed should be determined. A key, indeed we say fundamental characteristic of the license, and there's no dispute about this, is that it should be a continuous license, uninterrupted, entitling Xiaomi to continue business which it has conducted for some years, for years into the future. It would be surprising for that to be otherwise in the context of a continuing business. Yet what the pursuit of injunctions and restricting abilities to sell contemplates on the other side is that there should in effect be an interrupted license. It's actually completely contrary to the basis upon which the parties are contemplating that there should be a license, and contrary to the ETSI basis, on the footing that the whole point is that there should be unrestricted use of the relevant rights. It doesn't make any sense for a telecommunications standard to have an SEP license which is potentially interrupted. The whole point is that it should be to give the right to sell throughout the world on terms, in this case, that the parties agree to be found, namely those determined by the English court. So anything that undermines that freedom in the meantime is contrary not only to the ETSI scheme, but also even to Panasonic's undertaken to offer the FRAND license, that is the FRAND license in this case.
And that's backdated to when?
So at the moment, the license would be, the effect of the license would be backdated to whenever the products started to be sold.
Started being used.
There is.
You're saying that the undertaking is an undertaking to offer a license that covers the current period.
Oh, indeed.
And yes,
Indeed.
in the meantime, steps are being taken to disrupt
Indeed.
what would otherwise be due under that license.
Indeed. The continuous license.
Yes.
And that's not consequence free for the purposes of the actual license determination. Because let's suppose that an injunction is granted and there is, as a result, interruption in the license. What this court would then need to do, either at the hearing in October or possibly separately, is work out not the price of a continuous license, but it would need to work out what the price was of a interrupted license, because ex hypothesi, the license would have been interrupted for that period in Germany or the UPC. Now those values could be very significantly different. If one thinks about the costs of not being able to sell products in Germany or the UPC, that is an enormous disadvantage. And one of the points under a license, intellectual property license of any kind, is to take into account what the value is of the license to the licensee. If the value of the license to the licensee is diminished very significantly by it not being a continuous license but an interrupted license, that would need to be accounted for. Now, the consequence then for the UK proceedings would be not only that it would be dealing with the kind of license notionally that the parties have not agreed to proceed on, but it would then need to revalue the license that the licensee actually got as a result of the actions of the licensor. And my lords need to bear this in mind from perhaps coming to this area fresh, which is that Panasonic's portfolio is a relatively small portfolio of standards essential patents. There are many other standards essential patents, possibly ones owned by Xiaomi themselves, owned by other contributors to the standards, and technology that Xiaomi has itself created, as in the case of all manufacturers. An interrupted license means that a licensee is not just prevented from exploiting the patents in suit, the patents that are subject to the license. The licensee is prevented from exploiting a wide range of other patents to which the SEP owner has not contributed at all and are not the SEP owner's patents, but for which the licensee may already have paid, because they may have paid for them on the basis that those licenses with others would be continuous licenses. And so it is, in our respectful submission, obvious that this would give rise to at least a major argument about the valuation of the license, which the English court would have to resolve. So that is a reason why one might say that, however one frames the relief, whether it be in terms of anti-suit relief or in terms of an interim license, this is a gap in terms of the right to sell that has to be filled in order to fulfill the ETSI requirements and to give effect to the undertakings that have been given to the English court.
So it's both. Your case is that in particular, the potential pursuit of injunctions in other jurisdictions is contrary both to the undertaking given to this court and to the ETSI obligation.
It is, and the way we put it is this: the undertakings given to this court are given in order to give effect to the ETSI undertaking, if I may put it like that. So it's not just it's not completely separable.
No, but they have added effect and force.
Correct. So I think I've addressed these issues. The third point was the on-demand point, which I think I've already made. That's the Optus and Apple point in paragraph 39 of the Court of Appeal. And so the real question is whether or not that this gap should be filled. Now, we have articulated a number of advantages in doing it in this way, and in the light of the questioning from the court, perhaps I can just briefly summarize what they are, because in contrasting this with anti-suit, one has to come up with a rationale, accept for why this is a better solution, and may I just briefly explain why it is a better solution. First of all, because it gives rise to a kind of juridical advantage of the right of, under the ETSI scheme, for an alleged infringer to be offered a license now in respect of its acts in the future. So it's giving effect to the ETSI scheme, and we say that strong reasons would be required not to say that an undertaking should have a license now in respect of acts to the future. It's to put it the other way. The judge sort of put it the wrong way round. He was thinking, well, I need to find strong reasons why an interim license should be granted. In fact, under the ETSI scheme, insofar as it gives rise to the right to a license now, you need very good reasons why you shouldn't have a license now, particularly in the context of a continuing business. Second, may I deal with the commercial advantages? First, it would provide a means for Panasonic to be paid something in the interim. And we suggest that the only credible explanation for Panasonic saying this route shouldn't be adopted is that it is calculated that it might be able to secure a payment higher than Frank by pressurizing Xiaomi in Germany. Second, it would, in a sense, regularize the position in the meantime between now and the conclusion of the longer-term license, which might be regarded as commercially valuable. Third, it would be in accordance with what is a accepted practice in other collective rights situations, such as the Copyright Tribunal, and I referred to the EOS case. And one might then turn to what might be described as avoidance of disadvantages. It would reduce the transaction costs to avoid the array of unnecessary proceedings which are clogging the courts and create all of the sort of side issues. And although it's been said, well, the German courts want to decide all of these technical trials, or may want to decide them, there's really no evidence to that effect. My lords will realise that what the English court has done in relation to technical trials in these Fran proceedings is said, well, actually, can we just avoid all of these? And there's no reason why this court should assume that the German court is absolutely desperate to decide a number of SEP patent cases, which require a lot of technical evidence, and which may engage not only an infringement court, but may engage a validity court. One thing I'll come on to that's happened in Germany is that Panasonic selected its portfolio of patents that it wanted to assert to try and get these injunctions, went to the German court. The first hearing that there was in relation to what one assumes is Panasonic's best shot on this, the German court said, well, actually, we think this is maybe invalid. And so the German court has stayed those proceedings pending reference to the Bundespatentgericht to decide whether or not there is an invalidity of this allegedly great Panasonic patent. So the consequence of this whole thing going on is that you don't just have one German court, you potentially have two German courts engaged in having a look at technical issues which both parties agree make no contribution whatever to the resolution of the dispute before them. And there's no question that these debates are taking matters forward in any respect. So that is a big avoidance of disadvantage, and the disadvantages of all of the issues that would arise in relation to evaluating the interruption value, those are, in our respectful submission, self-evident. And so what does Panasonic say on this? It says, well, the pursuit of these proceedings may speed up resolution. I think that's really their point. It will bring the parties to an agreement. But there's no suggestion that that is needed to bring parties to a FRAND resolution. In fact, it's likely to yield exactly the opposite result, because the whole point of the German proceedings is that you can get an injunction without the German court evaluating whether something is FRAND at all. So insofar as they're used to pressurize Xiaomi, the pressure is towards either settling on terms that are, by the German lights, not obviously unfrand, and I'll come on to the very low threshold that brings, or on what might be called ransom terms, and the ransom terms being, what are you prepared to pay in order for us to allow you to continue to sell in the German market? So this is not a situation where you can say that the pursuit of these proceedings is likely to yield the result that the ETSI scheme is contemplating. It's actually likely to yield more rapid, insofar as it has any impact, it's likely to yield a more rapid production of terms that are not FRAND. And so there is a whole set of points that really are strongly against having something along the lines that Panasonic proposes, and a significant number of points that are advantageous to adopting the approach that we recommend. So can I then turn to the issue of just a few key facts? I think I don't need to spend a lot of time on that, since they're very well articulated in our skeleton. Can
I just stop you for one moment? What you prefaced the last section by saying you were going to contrast with an anti-suit and why it was a better solution. But I don't think I heard you mention that.
Oh, I'm sorry. You're right. What I was focusing on was the positives of an interim license. The thing about an anti-suit injunction is your lordship is right that it provides some of those benefits, in that it would make the proceedings in Germany unnecessary, it would avoid some of these issues. But what it wouldn't do is provide interim payments for Panasonic, And what might be said against it, if I argue my learned friend's point, is that it may be perceived as a slightly more jurisdiction versus jurisdiction battle, rather than saying, well, actually, this is the sensible way forward.
But we know that anti-suits act in personam, and the English court is very careful when granting them to make it plain that it is not seeking to tell the foreign court what to do.
Perhaps I can put it like this. Although it is a somewhat more complex solution, it is, to use the language of some of the European competition jurisprudence, the least restrictive solution.
Well, the anti-suit injunction solution simply means this court grants an injunction restraining the foreign proceedings. End of it. The parties then proceed to get their license agreed by the end of this year, beginning of next. Yes. Seems to me quite straightforward.
Yes.
And the license is retrospective.
Yes. Well,
as I understand it, the advantage you put forward for the declaration of an interim license, as you say, it's a juridical advantage for the infringer to be granted a license. But I don't understand that, given that will be granted in December or January retrospectively.
You're right. My point is that if one follows the scheme of the ETSI scheme, and your lordships approach this in the way that this court has approached the entitlement to be offered a ETSI license, it is an entitlement that arises now. It's not an entitlement that arises. It's an entitlement to be licensed
now.
That's
the position with all rights which are vindicated in the court, is that by definition you're seeking to vindicate a right which existed at the time you issued the proceedings. And unfortunately, as you say, it's an inevitable fact of life. The court doesn't get to resolve what those rights are and to give relief for a period of time. And the court is well used to the fact that it has, in some circumstances, to make orders to preserve the position in the interim. And it may be that you're going to be looking at the substantive law on interim relief in due course, but what the court generally doesn't do is deal with it and make orders affecting the substantive rights of the parties on an interim basis, because it might get it wrong, and those rights should not be determined on that basis.
Yes, and I take all of those points. Let me just explain what our answer is to those. The first point to understand is that a license has two elements under the ETSI scheme, obviously. One is a freedom to do acts, and the other is a right to be paid in respect of those acts.
Well, an obligation
to
pay.
An obligation
is
to
the
pay.
Corresponding.
Yes, a corresponding obligation to pay. Our point in relation to immediacy of license or on demand is that we have a right now to freedom to undertake those acts. That's not a question of an interim determination. It's not
on a FRAND basis.
Yes. Let me just come back to the second part. Yeah?
Yes.
On the basis that FRAND payments will be made.
Yes.
Giving rise to
and
the
that's
FRAND
what's going
obligation.
To be determined in October.
But an obligation has already been entered into to make the payments. The only thing that hasn't been done is the quantification. That's the point.
Yes.
So the license is to that extent complete. I mean, obviously there are detailed terms that may need to be worked out, but it is to that extent complete.
But is it for you to complain about the fact that Panasonic won't be getting any payments until... And surely that's not a point you can pray in aid, the fact that you don't have to pay them until December or January.
No, I'm not praying it in aid in this sense, but what I am saying is that if my lords are persuaded by the fundamental point that we make, namely that these foreign proceedings should not go ahead pending a determination in the United Kingdom courts. That gives rise, prima facie, to a anti-suit remedy.
Your point is that a willing licensor rationally would want to be paid sooner rather than later.
Correct.
And the only conceivable explanation for not wanting to be paid sooner rather than later is that in truth they are trying to extract a super profran rate.
Correct. And that is not in accordance with the ETSI scheme.
But hence the anti-suit.
Hence the anti-suit. And the key point is this. If my lords are persuaded of that fundamental point, you may say, well, you know, why do we bother going any further? They should just be anti-suited. They should give in to an anti-suit injunction, and we can all, as it were, go home. No, they'll get their money later. That's not the problem. And there is much to commend that, if I may respectfully say so. The question really for this court is whether, in dealing with remedies for this very particular set of circumstances,
Yes.
the court can and should do better than that.
Well, my difficulty at the moment is where you have a well-recognised, straightforward interim remedy, which you said has much to commend it, is why this court should embark upon something which seems to me has a lot of issues around it. I mean, the whole concept of interim declarations is difficult. In fact, it's a final declaration granted on an interim basis, which seems to me to be even more difficult. And it's one which all you're declaring is that Panasonic, or a party in Panasonic's position, would enter into that consistent with its ETSI obligations. It seems to me it's remarkably complex structure, even not getting into the question of what rates do you actually fix in this interim license. All that's a very remarkably complex structure to put into place when this court has a well-recognised remedy which is designed to hold position pending a trial, which is about to happen, and that's my problem. Why, when an anti-suit has much to commend it, do we not just go down that route and
Yes.
and then we can all not have to? I mean, it's difficult enough for the English court to determine a final license. To impose on the obligation as well to start dealing with interim licenses seems to me to be taking on a burden which is unnecessary, certainly as far as I can see in this context.
Well, I mean, we'll obviously think about that, and when I finish my submissions, think about it over the adjournment, and perhaps give a better answer in response. But our submission is that there are two strands here of thinking. One is, as it were, what might be called conventional anti-suit thinking, which is the bread and butter of the commercial world. And partly the reason for that is because in those contexts you quite often have two courts that are really doing the same thing, or potentially doing the same
Parallel
thing,
proceedings.
where there are parallel proceedings
Yeah.
resolving the same set of issues. In the context of, and that comes into a kind of collision with what might be called the intellectual property world, where essentially what you have is an attempt in good faith of parties to provide reasonable compensation in respect of the use of each other's rights, bearing in mind that working out what should happen in the future may take some time. Now, one can adopt alternative approaches to that. One could say, well, let's take what might be called the straightforward, simple, commercial thinking approach, and that has, in some senses, no problems to it. And then there is an alternative approach which says, well, actually, does it better meet the needs of this situation to grant not an interim license, but a final license now for an interim period? Because that's what we're talking about. This is not an issue about interim injunctions and so forth. There is no dispute that there is a right to a license in this period, and that the right to the license exists as of now. In conventional intellectual property cases where one's concerned with enforcement of a patent, usually the question is whether there's a right at all. And that's why the court is so nervous in making interim determinations. If it's clear, as it is the case, that there is a right that exists now, and that the financial remedy for it has been agreed, and when I say it has been agreed, it's that there is a procedure to which both parties have subscribed for determining what the payment should be. In those circumstances, one might say, well, the right arises as of now. And that's why one shouldn't be looking at this in terms of interim declarations and so on. What the court should say is the FRAND license, that is the right license as of now until signature of the later license, the subsequent license, let's call it that, is X. And the jurisprudence relating to interim relief, which proceeds on a very different footing, namely that there is an uncertainty as to whether or not the right exists at all, is not the same uncertainty as exists here. There is a right that exists here, and we know what that, and we know in principle how the value of that right is to be valued.
Thank you. Yeah, sorry.
Yeah, you were going to update us on the facts.
Yes,
We're
just
running out of time.
very few points on facts. You can really take them from the chronology. I think I've made the points. There've been hearings in Germany. There is a further hearing that's due to take place. The chronology is in the core bundle tab. Tab 5, and the key points are on page 68. Since the PTA skeleton, the Bundespatentgericht on the 25th of July, or perhaps it was just around the time of the skeleton, issued a preliminary non-binding opinion that they considered EP 193 to be invalid. And then there was a stay on the 12th of August. On the 2nd of September, so more recently, the Bundespatentgericht issued a preliminary non-binding opinion that it also considered EP 466 to be valid, and then there was a mutual...
Invalid.
Invalid,
Yeah.
Invalid, yes. And then there was an agreement to stay the proceedings, and the next steps are that on the 27th of September, so in a relatively few days' time, there's a second hearing in relation to 193, including consideration of the FRAND defence, and Panasonic hasn't consented to a stay of those proceedings, and as we understand it, Panasonic will be seeking an injunction at that point, and will be seeking an injunction in the UPC in October, and the other injunctions in due course. The other thing that you need to know in terms of what's happened recently, because this is relevant to the issue of whether of the terms, is a confidential matter, and it is at tab 20 of the core bundle, which is a communication that we received only last Friday. And I won't say the numbers for obvious reasons, but I would invite my lords to consider that number in the middle of the page and compare it with the number that was sought and said to be the appropriate figure only a few months ago. And what you see from that is that the probability, we would say, of Panasonic's approach being the correct one when it comes to the license is extremely low, and indeed it highlights a vice which I'll come back to in thinking about German proceedings, about the undue pressure that can be placed on a litigant in these circumstances. So those are the two key points. And can I then turn to the grounds of appeal and the points on good faith? First of all, the judge accepted that in principle good faith could lead to the creation or modification of a party's rights, both giving rise to a claim of damages, and it would in theory be possible to imply obligation to grant an interim license. And he said that there wasn't in this case, and we say that he was wrong, because what he had failed to appreciate was that it was not only a procedural corollary, but also was a corollary of the fact that there was a requirement to grant a license on demand in respect of acts for the future. His analysis, which was based on a consideration of what might be called interim relief, where the courts obviously say that there may need to be a high degree of assurance before particularly intrusive relief is granted, was actually flawed, because we're not in that situation. We're in a situation where what is before the court is a question of whether, as a final matter, these terms for this period are FRAND terms. And the evaluation should have taken place on the basis that, on the balance of probabilities, or taking all matters into consideration, the findings were, the terms that we were proposing were appropriate for this period. They were fair, reasonable, and non-discriminatory. Now, in connection with that and the overall approach, we respectfully submit that his analysis of the interrelationship between the FRAND terms here and the German court was not correct. And in order to understand that, perhaps I can just take my lords very briefly to one of the points of evidence that was common ground and to which the judge referred, so that your lordships understand what the real problems are in the approach that permits someone to pursue injunctions in Germany. It's in the supplementary bundle at tab 3 at page 54, and it's from the evidence of Dr. Christoph Ahn, and on these matters there was no dispute. It's paragraphs 59 and 60, so that you understand the context.
Sorry, which tab again?
It's in tab 3,
Yes.
page 54 of the appeal bundle, paragraphs 59 and 60. And he says, and there was no dispute about this, it was reflected in the judge's judgment, regional courts in Munich and Mannheim will find an SEP holder's offer to be obviously unfrand only in exceptional cases. I'm not aware of any case in either the regional courts in Munich or Mannheim when SEP holder has been found to be unwilling. Out of the 11 published decisions, they all consider the FRAND defence to be unfounded, and as a result granted the injunctive relief sought by the plaintiff SEP holder. And just to remind my lords of what the standard is that's applied, because that's reflected in the concept of not obviously unfrand. Not obviously unfrand is to be equated with not devoid of all reason. And one sees that from the explanation that Professor Meyer-Beck gave in the Lenovo and Interdigital case that we've drawn attention to in our skeleton. So this is an exceptionally undemanding test. But the undemanding nature of that test is reinforced by what Dr. Ahn says in the next paragraph, because although the regional courts of Munich and Mannheim can only make findings based on the evidence placed before them, and they can issue orders for production of documents, they don't have the authority to compel production documents generally, and it's the established practice that it is up to the SEP holder to decide which of its concluded licenses it presents to the court for determination. Now this is an established problem, in SEP jurisprudence, and one saw this, and one member of this court referred to it in the decision in IDC and Lenovo, where IDC originally put forward 20 signed licenses and said this is the basis for our claim. Those were found by the judge to be completely inappropriate as comparators. And that was partly because under English procedure there is a requirement to disclose other licenses, and it was found that other licenses were the correct comparators. So the problem with the German court's approach, if I may respectfully say so, is that this gives rise not only to two problems. First, a very undemanding threshold for evaluation of what the SEP owners says is appropriate. But secondly, on the basis of completely selective information which the SEP owner may be able to present to the German court. It is, if I may respectfully say so, an absolute recipe for the grant of injunctions, despite the fact that the agreements in question are not FRAND, and to require defendants to enter into agreements or pressurize them into doing so, even though even the claimant may not defend those agreements as FRAND. Because what happened in the IDC case, once the court had dismissed all of these, the so-called IDC 20, the SEP owner didn't even dare to say that that dismissal was wrong. They didn't suggest that there was anything inappropriate about that. So this is a situation where one has got a recipe for that kind of error occurring. And we respectfully submit that that enshrines the possibility of hold-up. That's actually an expression of hold-up of the kind that the ETSI scheme is intended to avoid. So as to the application of the wrong standard, we respectfully submit that the judge just didn't approach this in the right way. He ought to have concluded that this was a case where there was a material risk that hold-up would or could affect the ultimate outcome, that was to be avoided under the ETSI scheme, and that the way most in conformity with the scheme of avoiding it was for an interim license to be put in place. And in our respectful submission, that is a point really that is the fundamental issue in this case. It affects the whole of the approach that the learned judge took. We have outlined in our skeleton argument the points where we say that he erred in principle in relation to the evaluation of good faith. But these are really both questions of fundamental approach and in some circumstances, as we have articulated, at specific points. So the key points there are that he approached the matter on the basis that Panasonic's FRAND commitment required Panasonic to make an offer on FRAND terms no more and no less. So far, so good. But what he did not do was go on to then evaluate how the use of injunctive proceedings against the background of the undemanding standards of evaluation applied by the court from which the injunction was sought gave rise to a material risk of a non-FRAND outcome. And if he had analysed it in that way, we respectfully submit that it is inevitable that he would have concluded that some means should be put in place in order to avoid that. And the means that were the most appropriate, least intrusive means, were the means that we respectfully commend. Interim license is, in short, a natural corollary of the duty to act in good faith, and we respectfully submit that if the court is, in a sense, stepping in to the party's role of acting in good faith, then the court should do what the parties would do, namely make an agreement. And the way in which the court does this in the context of the English Frand jurisprudence is to make declarations as to what terms are Frand in for the relevant rights, and provide appropriate remedies if those terms are not entered into by the respective parties. So, in our respectful submission, as we've said in our skeleton, but really can only repeat it, that there are fundamental issues as to the approach that was taken by the court below. We have identified that there are also particular issues in relation to the analysis of German proceedings and whether those oh, yes, I'll come back. And we've articulated those points in relation to what the German courts are likely to do, and whether or not the SEP owner can maintain or alter its licensing offer. Implementer is obviously placed into an invidious position where it's facing an injunction if it doesn't enter into an agreement that is not Frand. I mean, that's the whole purpose of the exercise, and may be valued not even by reference to the value of any of the patents, but merely by reference to avoidance of a ransom. And if one then makes concrete some of the points which the judge did accept, namely that there was a difference between, potentially a difference between a not obviously un-Frand offer and a Frand offer, in a sense obvious, the magnitude of that potential injustice can be quantified. Because if it's right, as I think Panasonic submits, that its original approach, which was very different from the one that I've shown you, was not obviously un-Frand, and maintains that position, what is happening in Germany is that an injunction is being sought to require us to pay sums which not even Panasonic says are appropriate sums, on the basis that the original approach is not obviously un-Frand. Now, it is difficult to think in the context of avoiding hold up of where the parties have agreed to dispute resolution mechanism, of something that's more likely to be contrary to the ETSI scheme. And so in our respectful submission, in those circumstances, what the judge should have done was to say, okay, that there is a clear risk here of a hold up, and the declaration sought is a way of ensuring that the risk is ameliorated.
Can I understand that? Are you saying that the judge was wrong to consider these matters on the standard of a high degree of assurance?
Yes. We say that what the judge ought to have, I mean, we say it does, in some senses it doesn't matter, because we say that the judge ought to have had a high degree of assurance that, of at least two things. One, that there was a right to a license now, because that's not really in dispute in respect of acts. And secondly, that there was at least a risk that the grant of an injunction in the interim would result in suprafran terms, or that if it didn't, because Xiaomi didn't succumb to the pressure, that it would result in the license that was contemplated being a very different license from the one that, that the parties had agreed to.
Could I just understand this? Because your ground one is the judge consistently and wrongly applied the standard of a high degree of assurance. But he recorded, paragraph 87, that it was common ground that was the standard, it being a final injunction. But was he wrong in so recording?
I'll just check that.
It does seem to me it is the right standard to apply.
Your skeleton argument takes issue with that being common.
Yes, we don't accept that that was a concession that was made, and we respectfully submit that this court should consider whether that is the right approach in a case of this kind. But as I've said,
this is relief granted without a trial on an interim basis. On what basis should the court decide grant final relief without a trial, other than on the basis of a high assurance?
I understand that, and perhaps, I mean, it may be said that this particular point, or the consequence of it, was the thinking on this has developed. And the reason I say that is this: if I'm thinking about what the court is being invited to do on an interim basis, it is being invited to say, finally, that this license is the appropriate one for this interim basis. That doesn't require the court to say that it needs to have a high degree of assurance as to all of the matters in question. Can I explain what I mean by that? In relation to the right to a license, there is a right to have such a license on demand. It's not a question of a high degree of assurance at all. There's no dispute, really, that there's a right to a license on demand in exchange for payment. So, to that issue, the question of a high degree of assurance doesn't apply. The area to which the judge really applied the high degree of assurance aspect was the question of whether it was necessary, in order to make the declaration that he was seeking, to have a sufficiently high degree of assurance that the steps taken by Panasonic would lead to a suprafran license. That was the essence of it. And our central point on this appeal is that that was the wrong approach. He didn't need to be satisfied at all, whether on a high degree of assurance or otherwise, that this would lead to a suprafran license. He only needed to be satisfied that there was a material risk that, because of the approach taken by a combination of Panasonic's and the rules that they were invoking, there was a material risk that holdout would affect an agreement. So hold up would affect an agreement. And so In some senses, this is reinforcing my point, which is that the issue really is one of approach to the question of good faith, rather than an issue of the precise standard. The precise standard of approach is one that's appropriate in context where one is thinking about the uncertainty of something that may happen in the future that one is seeking to prevent, or the uncertainty of the basis of rights.
But the key point, surely, of the declaration at the end is obviously its terms as to the license, but also the conclusion that in the event that Panasonic does not grant the license, it is an unwilling licensor. And that seems to me to be, that's crucial to you be able to resist the injunction in Germany. But surely the court has to be very careful where Panasonic has agreed to accept the license granted at the end of a trial, to make an interim declaration that Panasonic is an unwilling licensee. And I thought you'd have to a high degree of assurance, I think, underestimates what you'd have to be sure about to make such a declaration.
I understand where my lord is coming from in that case. And it might be said that there are two aspects to this case. One is the question of unwillingness as a licensor or licensee. And the other question is whether or not the court should...
But you need that, don't you? Because that's the only way that you avoid the injunction.
No, I don't need that. And I'll explain why.
Right.
One of the lessons of the IDC and Lenovo case was there was an enormous amount of dispute backwards and forwards relating to the issue of the conduct of the parties during the course of the negotiations. The court below and this court, the Court of Appeal, said, well, look, that isn't really the point. The point is the license terms. Now, if this court were to say a license should be entered into on terms X, because we think this is an appropriate course for this period, and that Panasonic should offer that license, and Panasonic were to refuse to offer that license, in those circumstances, one might say, well, Panasonic has demonstrated that it is unwilling with respect at least to that license, to that period. It is unwilling to grant a license during that period. And so the issue of whether someone is a willing or unwilling licensee can depend on their response to a given situation. Indeed, that's the purpose of the European jurisprudence. You look to see what's been done at the outset, and you look to see what the choreography is.
But this is the English court declaring
Indeed.
that it would be an unwilling licensee.
Indeed, and the English court can certainly declare that, because if the English court says, if Panasonic were to refuse to enter into such a license, which is the appropriate license in these circumstances, Panasonic would be an unwilling licensee with respect to that period. And on that...
Unwilling licensor to that extent.
To that extent. It wouldn't require the court to go any further than that. And it may well be that any relief that the court would grant would be limited, in a sense, to that extent. But it doesn't need to go further than that. And indeed, one of the issues before Mr. Justice Mellor and this court in the IDC and the Lenovo case was the extent to which one needed to get into this whole issue at all. So
that's a separate point, because the point there is that once you are actually determining brand terms, actual willingness goes out the window, because you are considering a hypothetical willing licensor and a hypothetical willing licensee. So the actual willingness of either party is completely irrelevant. But at this stage, it is relevant. At this stage,
it is. In respect of a license, which the court has declared is a license that the licensor should offer. And in all respectful submission, it's almost a corollary. If my lords are unconvinced that Panasonic should offer a license on an interim basis, then in some senses, the issue of unwillingness of licensor doesn't matter. If my lords are convinced that that is what should happen, then my lords can properly declare that, and also declare that if they do not do so, they would, to that extent, be an unwilling licensee. Because the whole point of this entire jurisdiction is to secure licenses as of now that go forward to the future. And so in our respectful submission, whether you apply a standard of high degree of assurance or not, this is a situation where if you are satisfied that this would be an appropriate response, you can so declare. So I think my lords have got the point that the German courts are not determining global FRAND terms or rates, and they're only considering the devoid of all reason issue. And we have drawn attention to the issues that would arise under that head. So we respectfully submit that the approach taken by the judge to this issue just did not do justice to giving effect to the ETSI requirements. And if he had had those points in mind, he would have approached it in quite a different way. He would have said, is there a useful purpose in granting this declaration? Does it have a real prospect of avoiding hold-up? Is it sufficiently modest in its terms? And when I say modest in its terms, because adjustable, not to be problematic. One of the problems with granting interim relief is that it is in some senses final in respect of a period. But if one grants interim relief that provides for a permission with financial terms that are adjustable, what effectively one is saying is that the number in question is a provisional number and might be adjusted. So the issues of high degree of assurance simply don't arise. Then the question is the number correct? And what the judge did not need to do, whether as on a high degree of assurance or otherwise, is get into a question of whether what the subjective or objective intention was of Panasonic, although we respectfully submit that it is self-evident from their conduct, including the point made by my Lord Justice Arnold, that the object that Panasonic has is to secure terms that are not FRAND, because otherwise why on earth would one take the course in question? And as soon as you appreciate that is the object, and it's the only rational explanation for the course of action given the history, then the court, in our respectful submission, needs to consider the question of the remedy for that. And that brings one back to my Lord's point as to whether the remedy should be the simple remedy of anti-suit to address it, or whether it should be the remedy that we say is appropriate. But in our submission, there should be no question about whether this needs a remedy. So can I then turn to comity, deal with this briefly. The judge said that he thought that the declarations would not only serve no useful purpose, they would be an exercise in jurisdictional imperialism. And he said on this that there wasn't any need to clarify the parties' rights because Panasonic wasn't seeking injunctive relief here. And we respectfully submit don't understand that point. That here the English court is valuing inter alia the German patent rights. No one is suggesting really that an injunction should be a primary remedy in relation to any SEP rights. whole point of the SEP and ETSI scheme is that people are entitled to go ahead. So injunctions are only a kind of backstop generally, not a primary point, and will not. Panasonic was seeking injunctive relief here is neither here nor there. The second point, which is really the committee point, is that he thought the declarations were to influence the outcome of the German proceedings, and there's reference to Teva and other cases. And in our respectful submission, that is not what is happening here. What this court is doing is not, as in Teva and Novartis, making points just to assist the German court. The points that are the declaration that is being sought here is in part to ensure that this court's powers, and in particular the parties' agreement, is upheld, that what is FRAND as determined by this court. My lords, of course, have the point that that a declaration, indeed even an anti-suit injunction, is an order in persona. It's not directed to the foreign court. But if one's talking about saying this is the license you should offer, it's the paradigm of something that isn't directed to the foreign court. Now, of course, it may be the case that the German court or the UPC take account of what this court says in relation to this and take a view. The German court can, of course, do that. But that's no different from any decision of this court affecting foreign courts. We would say that they would be right to take it into account if my lords acceded to our...
Well, you say it's the same argument as in Unwired Planet.
It is.
The whole point of Unwired Planet is it says the English court can determine the terms of the licence, which are global.
Well, we've made that point in our written submissions, that this is once one accepts that the English court can determine terms of a license that are global, then the point falls away, because everyone accepts that to that extent the English court is in charge. And I'm not saying the English court is like top dog in some senses, but the reason that it matters in this case is because the English court is doing it by agreement with the parties. So this is giving effect to the parties' agreement.
As a newcomer to this area, perhaps you can help me with this. I understand that's what the Supreme Court said, but is that applicable to an interim licence granted without the court actually determining with a trial what FRAND is?
We say yes, because in fact what the court is doing is determining what is FRAND for the interim period. That is determined finally.
But without a trial.
I mean, there was opportunity actually on both sides to cross-examine. This was a trial of the issue of whether there should be an interim license and what the terms were.
Was it a preliminary issue?
I don't think it was formally a preliminary issue. I'll need to check on the procedural issues on this, but this was not an interim injunction application of the kind where one has, as it were, provisional conclusions. This was attempting finally to determine what should happen for this period.
I need to understand what it's not a Part 8 claim, it's a Part 7 claim. Is it a...
My lord, if I can help, there was no preliminary issue directed. It was an application notice under CPR Part 23. It is true that in the run-up to the hearing, Jeremy threatened an application for permission to cross-examine. We opposed that application. Ultimately, it was not pressed because the parties proceeded on the basis that the evidence could be agreed insofar as it mattered. So it's quite wrong to suggest this was a trial. It was nothing of the sort.
But it was a hearing to determine whether there should be a license and the terms, if there was to be a license, of that license.
Indeed, it was an attempt finally to dispose of that issue.
Yes.
Which is why we say, and as the judge accepted, and indeed as Jeremy agreed at the time, high degree of assurance was the right test in the usual way.
It's the form of the hearing that we were asking about. Yes.
So,
But forgive me, my understanding is this wasn't a court ordered hearing to determine the terms of an interim license. It was an application by the implementer that the court do order an interim license.
yes,
And that application was dismissed.
yes.
So there was no question of the court having undertaken the determination of an interim license.
No, I agree. But the difference between an interim license and a final license in this context is this: if the basis upon which an interim license is sought is not what is FRAND in the sense of what the exact numbers that should go into the ultimate final determination are, but what is the license that should operate in the interim, then one doesn't expect there to be extensive evidence in relation to valuation and so forth, because the court is not undertaking that exercise. What it is seeking to determine is whether, for this period, pending fuller consideration of the fuller license, including for that financial terms during that period, there should be a license. And that's why we say this was framed in terms of an application, but it was for final relief in respect of the period for which with which we're concerned. And the reason that it's interim is because there was to be a reassessment of the financial terms.
Yes, but unless you tell me otherwise and point it to me, I'm assuming that we are proceeding on the usual civil procedural rules as to how one deals with interlocutory applications. There's no special procedure involved here as to the determination of this issue. It was you made an application for an interim license, for a declaration that there be an interim license, and that was refused.
Yes,
and that is procedurally what happened.
Absolutely.
Yes.
But the reasons why the court adopts the approach of high level of assurance is because if it is making particularly intrusive orders that affect the parties' rights, it should be assured that those are not going to be irrevocably affected.
Well, no, it's the other way around. It's because they're irrevocably affected that it has to have a high assurance.
Yes, my lord is right to reformulate it, but it's the same point. The point is that because there may be irrevocable impact on a party's position, the court needs to have a high degree of...
It's not American cyanamide.
No.
Because it's making final orders that affect the party's rights.
Indeed. But where you have a situation where the purpose of the order is to make payment provisions that are themselves provisional, the issue that arises in relation to high level of assurance is simply a different issue, because the whole point is that they're not irrevocable.
I understand that.
That's the reason why we say that this approach is just not applicable in a situation where
we came to all this was I was asking you, appreciate taking your time, I was asking you whether the Supreme Court decision in Unwired Planet addressed the question of whether or not the English court could grant an interim license globally.
No. This issue has, so far as I'm aware, never arisen at a level other than High Court. I mean, before this case.
I mean, I can see it's one thing for a court of competent jurisdiction to make an order which has by its nature global effect, but doing that on an interim basis, to say that an interim order made on a Part 23 application should result in a global license seems to me to be a wholly different kettle of fish.
Your Lordship is of course right that it hasn't arisen, but you may think, perhaps I can invite my lords to think about it in this way. What the Supreme Court was doing in Unwired Planet was something much more extreme than we are seeking here. Because what it was saying was that the English court has the right essentially to value patents globally and exclude from the market anyone who doesn't pay in accordance with its valuation, and for that to be a permanent exclusion if they don't pay, and for that to be a permanent non-provisional evaluation.
Yeah.
So our submission is that if the Supreme Court considers it appropriate for that kind of order to be made, and everyone accepts that should now be done. Indeed, one sees that people are wanting this to be done, generally. The order that we are seeking is a far more modest impact than
Well, it's
that.
an extension of that, isn't it?
It's not an extension of it. It is actually doing something less, because what it is saying is, in order to preserve the unwired planet jurisdiction.
Yes, but it's piggybacking on that jurisdiction. You've got to have that jurisdiction to start with, and then this is adding to that, saying not only can you determine FRAND and apply it globally, but you can do it on an interim basis in order to preserve that power.
Well, but you might say, well, that is, you can do all sorts of things under interim basis in order to preserve that power. But the point here is, if one makes a FRAND determination under the unwired planet jurisdiction, that is saying you have to pay whatever it is, 10 million or whatever, finally, for all of these rights around the world. That is the FRAND determination. What is sought on this application is to say you should pay X in the interim, pending determination of a redetermination. Now that is it is much more akin to the court exercising a power to make an interim payment on account of costs, or interim payment on account of damages. The court doesn't need to have a high level of assurance that the sum in question is definitely going to be recovered. What it tends to do in that kind of context is to err on a modest side and make a reasonable payment, or require a reasonable payment in those circumstances. And that is a much less intrusive, much less final determination than the unwired planet determination contemplates. So my lord is of course right to say that it is something different from unwired planet, but your lordship should also bear in mind that it is doing something less than unwired planet in a real jurisdictional sense.
I think we need to let you move on.
Yes.
For the time.
I've actually made quite good progress on
good.
this.
Okay.
On useful purpose, on that.
You finished with comity.
I think so. I mean, I think my lords have the point that we're not. This is not an order directed at the German court, even though it may be a response to Panasonic invoking the German court, and that's not doesn't give rise to a comity issue. There is one other point, perhaps, that my lords may want to bear in mind, which is that sometimes with comity issues, the court can be concerned that the English court is treading on the German court's, or treading on a foreign court's right to determine the same thing, essentially, that the English court is determining. In some countries, you've got parallel proceedings which are determining the same thing. That's not what's happening here, because the German court is not going to be determining FRAND terms at all. Where you have a situation of this kind is much more akin to one where there is an exclusive jurisdiction clause in an agreement, where parties have agreed to submit a particular issue, in this case the value to be extracted inter alia from the German patents, to the English court. In those circumstances, an attempt to go to a different court to seek a determination, or in this case pressurize a settlement, to undermine that proceeding, is not in substance different from undermining an exclusive jurisdiction clause. It is not an exclusive jurisdiction clause in terms, but it is in effect, because this is the only court that the parties say should be determining FRAND, and it is a court to which both parties have submitted that dispute. Now that is as close as you get to that kind of situation.
Can I just be clear on that? Because I understand the point that the statistics show that the number of FRAND determinations in Germany to date is 0. But I understand that you go further than that. And my question is this: do I understand it to be your submission that it is yet to be established as a matter of German jurisprudence that the German courts have jurisdiction to settle FRAND terms on a global basis at all?
Oh yes, and if I hadn't made that clear, I should have done. It not only is it yet to be established, the common ground between the experts was that they don't do it at all.
Well,
and
yeah, but there's a difference between not doing it, which is, there's no dispute about that, it's 0. But the question I'm asking is it actually one that they are capable of doing?
well,
To which I think the answer is, it's an open question, but it's certainly not yet been established.
first, it has not been established, and second, although I'll need to check the expert evidence, I don't think there was any evidence before the judge suggesting that the German courts could do it as a matter of German procedure, that they would exercise a power to do it, or that their doing it was even in contemplation. Indeed, their approach is completely different. They approach things on the basis of Orange Book offers and so forth. So this is not a situation where the English court acting would be preventing something that one knew that they wanted to do or were interested in doing. But it doesn't matter for the purposes of this case, because in this case, whether they can do it or not, the parties have agreed that it's this country that should be doing this determination. So, useful purpose, well, we respectfully submit there are multiple useful purposes. There is a Panasonic's we won't do it anyway point, and on that we say, first of all, that Mr. Jelfs's evidence is entitled to some respect, but that was some time ago, and it certainly doesn't follow that if my lords make a declaration, Panasonic would essentially ignore it and say, well, we're not offering those terms. And there are a number of good reasons why they may not do that. First of all, because the period of the interim license is now shorter. It's only a period really from now until, say, Christmas or early New Year. Second, Panasonic themselves may come to appreciate that the refusal to grant an interim license not only would deprive them of money in the meantime, but may ultimately, for the reasons I've explained, actually reduce the sums that the court may consider it appropriate at trial, take account of the fact that the license is discontinuous or sought to be discontinuous in major markets. So that there is not just not a plus, there's actually a potential minus in their not doing that. Third, it is well known that the European Commission authorities are looking at this whole area, and if a substantial undertaking refuses to enter into a license which an English court considers appropriate, that may have competition consequences and may increase the pressure on regulators to act in this area, which Panasonic may wish to avoid. And my lord has seen the document in relation to the financial proposals, which suggest that it is not able to sustain the request for payment that it was previously making. And finally, it is not to be, one can't discount the fact that this approach, or at least a less advantageous approach to Panasonic, was one that they themselves took only a few months ago. So this is a situation where the court, in our respectful submission, if it thinks it's right to do so in principle, should act in that way. So can I then turn to the terms that are that we say that the license should be made on? My lord will have seen the financial figures. The figures are confidential, but submission is that we are, in principle, with a few tweaks, content with the overall structure of the license approach that was proposed by Panasonic, which is in its Frown Amendment Statement of Case for this period, subject to terms that are adjusted to take account of the interim nature. My lords will find that, and I don't want to read anything out, in tab 19 of the bundle, and the monetary terms would be those that we were proposing before the judge, and we respectfully submit that they are reasonable, and I will try as non-confidentially as I can to explain why. The original basis upon which an offer was made is explained in the evidence and is explained in our skeleton, and that was increased. The sum in question is one that, in our respectful submission, provides a reasonable rationale for its payment in the interim, particularly having regard to what's happened recently as regards the adjustment of the claim, and the alternative approach, which is the Panasonic's non-enforcement offer, which suggests that an implementer should pay what is demanded, is actually a recipe for abuse generally. One of the problems in this area, which my lords will be familiar with, is SEP owners making far inflated claims, but the claims not being so inflated that they can be completely dismissed as being devoid of all reason. Now, if one adopts an approach that a implementer has to pay sums which are not devoid of all reason, even though the court, from the statistics one's seen so far, knows that those are likely to be, in many cases, hundreds of millions of pounds out, the consequence on the market generally would be extremely severe. What one would then have is a situation in which essentially what the court would be looking at is payments that were made on the basis of a hold-up entitlement, so the sums that should be paid in order for it to be said to the German court or whatever court, these are appropriate sums. And for manufacturers who have cash flow issues, actually making products, there would be no real justification for that. Moreover, if one thinks about that approach...
Sorry, can you just clarify where this submission is going? Because, let's take a concrete example, because it makes it easier. And it's in the public domain to some extent, namely what happened in InterDigital and Lenovo. So, in that case, there were demands made by InterDigital as the second owner for payment of various sums, and a long period of refusal by the implementer to make any offer at all, and then finally, fairly close to trial, an offer was made. And the end result was a figure between the two, between InterDigital's final position at trial and Lenovo's final position at trial. Now, it's fair to say that the judge's view in that case was that the commercial winner was Lenovo, because although the sum he awarded was higher than anything they'd offered, it was closer to their offer than it was to anything InterDigital had offered. But nevertheless, the fact of the matter is that the award was between the two. So the likelihood is, things being, human nature being what it is, that the outcome may be similar in this case. It may be, obviously one doesn't know till one gets to the trial, and it's all gone through and the decision is taken, but it between the two parties' positions. So, what's the relevance in that context of the fact that the decision may turn out to be less than what Panasonic were asking for?
I'm sorry, my lord. I think I wasn't sufficiently clear in the purpose of this submission. Panasonic's point, as I understand it, is that we should pay what they demand on an interim basis. And my point on that was that if that is the rule, or at least an approach that's taken by the court, that is actually a recipe for enshrining hold-up. And the reason is this. One thing we can be sure of is that while these awards are not always exactly what the implementer says, they are regularly very significantly lower than what the patentee says. And if the patentee can say, well, I'm going to maintain a claim, because they do, for example, in Germany, that is not wholly unreasonable, not self-evidently unfran. And they say, well, you should then be paying a sum that is not self-evidently unfran, even though this court knows that sums that are not self-evidently unfran are likely not to be fran. That would, in our respectful submission, be fundamentally wrong. Now, the question of what should be paid on an interim basis depends on a number of things. One is the time until final resolution. Another is the approaches as pleaded or developed in the parties' cases. And if the court can see that the time until resolution is not very great, that there has been sufficient guaranteeing of the royalties due, and the issues in terms of delay of payment if they arise are not great issues, then the court should, in our respectful submission, say, well, we will make some award, but it will not be close to what the SEP owner seeks. Because one thing we can be pretty sure about is that the SEP owner is going to try their level best to ensure that the sum...
But that might be thought to lead to the conclusion that, okay, you don't order what patentee is demanding, but equally you order a bit more than the implementer is offering.
It might lead to that conclusion. And in some senses, one doesn't seek to tie the hands, because that's exactly the evaluation that may take place. Our submission is that what we have proposed is a very generous contribution, bearing in mind all of the facts and circumstances. And
am I right in thinking that at bottom, the justification for what you're proposing is that, albeit it's rather less than what Panasonic are saying is fran, it's better for them to have that than nothing in the interim period?
And it's a reasonable sum. I mean, it's a very substantial sum, actually. And if one compares the approach under the interim license with what might be called the Huawei and ZTE approach, which doesn't suggest that there should be actual payment during the period of negotiated settlement, but that the implementer should set aside money and ensure that there is security for payment. What this proposal amounts to is going further than what the Court of Justice suggested was the approach of a willing licensor and willing licensee in actually making a payment over of a reasonable sum pending resolution of the dispute. And partly, it picks up on my Lord's point earlier, because the sum in question is so large that we are offering, for someone to turn that down and to say, no, we're not entering into a license on those terms, even if it's adjustable, that suggests that they think that they are going to get X plus delta benefit from not entering into such a license. And the X plus delta benefit is likely to be the delta between, just because that's the basis upon which the injunctions are pursued, the difference between what is in fact FRAND and what is only asserted. One might say asserted in a way that cannot be struck out to be FRAND, because that's the threshold, in effect, that the German court is applying. Devoid of all reason, not devoid of all reason. And in those circumstances, and bearing in mind the whole context, we respectfully submit that that is the sensible approach in a case of this kind. Now, my lord say, may say, well, that there is a complexity about the licensing and the valuation. Actually, there isn't. If one, in this case, there may be in some cases, but in this case there really isn't. Because the overall structure that we are commending to this court is one that is actually Panasonic's own proposed structure for the final license, just with appropriate adjustments to take account of the fact that it is an interim license and with the monetary terms obviously adjusted. So there isn't a fundamental dispute here about the nature of the terms of the agreement, as there may be, where the court has to fashion a whole lot of terms and schedules and so forth. This is, in some senses, a simple case, because all it requires is very modest modifications. And in circumstances where that is the case, we respectfully submit that the difference between the anti-suit remedy, which is the alternative that has been postulated, and the interim license remedy, and the concerns about the interim license actually go away. And it's partly because there is agreement between the parties on the bulk of the issues. And where, again, as here, you have terms that are adjustable, which is the proposal, obviously, that the terms should be adjustable in due course. Again, there is no problem as to making an interim license in those terms. And so, in our respectful submission, that is an approach that should commend itself. It is the most consonant, we would respectfully submit, with sensible licensing procedure. It is the most consonant with IP licensing generally, and it would support the procedural requirements of the ETSI scheme in encouraging FRAND in this case.
Now, you drew attention to what had come in from Panasonic last Friday.
Yes.
That, of course, is for the final FRAND determination.
Yes.
Has there been any movement on what they were proposing at the hearing of the present application?
I don't. I think it's the adjusted figure which is proposed. So I'm just being a little bit careful about what I say on confidentiality.
Well, obviously, figures are confidential, I understand that.
If you look at footnote 10 of their skeleton.
Says Panasonic has updated its revised non-enforcement proposal accordingly. Well, where do I find that?
I'm not sure that we do actually find it formally, which was, I think, the formal answer to my Lord's question. I think what position is that they are or might be prepared to do so on the basis of the terms of
You mean it translates through directly?
tab 20, but I may have got that wrong in terms of the correspondence. But my point remains, that I made just in the last minute. This is what Panasonic has adjusted to. But the very fact that we are looking at an adjustment made on Friday of the magnitude that you see as between what the condition was for not pursuing these injunctions last Thursday, which for all we know they may be still saying is the appropriate approach elsewhere, is very striking.
I made that point earlier, and I'm still trying to bottom that out in the mind, because I mean, the tab 20 proposal includes a lump sum, whereas I couldn't see that there was a lump sum in the tab 19.
No, and that's why I said that the financial terms. My point on tab 19 is that the structure of the license is the correct structure. It will just need to have a number put in, namely a lump sum that's adjustable.
You're making a forensic point that Panasonic moved in terms of the final number, and what I'm interested in is how much have they moved? And I'm struggling to find that.
Oh, I'm sorry.
Because I'm trying to compare a lump sum that I see.
Oh, no, I'm terribly sorry. In that case, that's my fault, because I thought you had the earlier lump sum in mind. I will just find it. It's in Mr. Jelf's evidence. Supplementary tab 7. Paragraph 27. And I mean, the number appears in a number of places, but I think this is the original place where it appeared. And it's the number in red.
Red number in paragraph 27.
Yes. And the forensic point is this. From April until last Thursday, that was the number. And my lords can compare that first, your lordship's selves. And the forensic point is the obvious one. Unless I can assist you further at this stage,
questions.
those are my submissions.
Thank you very much. We'll adjourn now till 2 o'clock.
Rise of the evening.